I know you're an extremely well-versed audience in terms of TTIP and how it works, and I'm sure you are on ISDS as well, but I'll just go back to basics in case not everybody's heard of it, and in doing so I will do it clearly from the perspective that we bring to it. So I'm sure you're going to hear different perspectives on the panel today. But for us, ISDS is, I mean, it's a horrible, like, imagine trying to work on a trade agreement, a trade and investment agreement called TTIP for a start, and then you've got to start explaining something called ISDS. And that's the second problem. So we just call it a corporate court system, essentially, something that allows foreign investors or multinational corporations, in the most part, to sue governments in tribunals overseen by corporate lawyers. And up to now, mostly these tribunals have taken place in secret, and there's not normally a right to appeal. So even losing, even if the corporation loses a case against the state can still be left with a hefty legal fees to pay. And indeed, that happened in the recent case with Philip Morris in Australia. Many people say, well, this shows the system works because Philip Morris lost the case on plain packaging against Australia, but Australia's left with $50 million in damages that it has to pay, in legal fees that it has to pay, despite that. So the other thing to say is we talk about this in the context of TTIP, but of course these things already exist in multiple different trade agreements already, bilateral and multilateral trade agreements. So, and under these trade agreements, hundreds of cases have been taken against, I read, more than half the world's countries. And so there's many cases that we've got to look at and examine, which show us what may be facing us under TTIP, but regardless of whether TTIP is passed or not, we'll continue to face many countries around the world. And it isn't all developing countries, and in fact the main example I'm going to give you is Canada, which is the most developed country under these ISDS systems, because Canada made the mistake of signing NAFTA 20 years ago now with the United States and Mexico. And I think Canada's a very interesting example because it gives us some insight into what could be facing us in Britain as another country making a trade and investment deal with the United States of America. Interestingly, the United States has never lost an ISDS case. We'll see what happens with the Keystone XL case, which has been brought now. The claim that's brought is that a government has acted unfairly. So it's treated a foreign corporation in a different way from how it would treat a domestic corporation. Or this wonderful phrase that it's indirectly expropriated the assets of an investor or corporation. How do you indirectly expropriate someone's assets? Well, because this is a developing area, and lawyers, as we've already heard, are extremely creative in this area, the definition of what that means is expanding all the time. So if you directly expropriate someone's assets, you seize their factory or something like that, take their property. But if you indirectly expropriate, it's something a little bit less tangible than that, and obviously in the case that Philip Morris made against Australia, the idea that simply making a public policy measure that reduces the sale of cigarettes is tantamount to indirectly expropriating someone's assets. That was the case that was being made. But it could be all manner of other things. So we've heard cases of Egypt being sued because privatized the former public utility which has been privatized, the water service in Cairo, was faced with an increased wage charge because the minimum wage was put up. So they claimed that was indirectly expropriating their assets, and many other examples which I'll come on to as well. So it's very broad, and to be honest with you, it's come to me little more than the profits I expected to make, I can no longer expect to make. And if you think about it, virtually any aspect of public policy is likely to impact some business in that way. So that's really one of the reasons why we're most concerned about it. That essentially it's action that can be taken simply for a government pursuing public policy, environmental policy, even when it's been elected to undertake that policy. It can either act to provide compensation to the investor that says their interest has been damaged, or it can, even in the worst circumstances, I would argue, put off a government from undertaking an action that it believes should be taken or has been elected to take. So for me, I'm less worried about, I mean, you know, it's not irrelevant that these tribunals often happen in secret, or that there's no right of appeal, but those things can be ironed out, and the European Commission has been pressured into ironing out those problems when it's come up with this investment court ICS concept. But for me, the fundamental problem with these things is that they essentially provide a parallel legal structure that is open to foreign investors and foreign corporations, but is not open to anybody else. And I think that's a fundamental injustice. And it is fundamentally giving capital far more power, legal privilege, than other parts of society. And it was interesting that somebody mentioned earlier, well, you can envisage a system in which other parts of society also have this legal access. What I find very interesting is the countries that tend to be most keen on ISDS, the United States and the UK being two of the primary ones, are the very same countries that for years and years and years, whenever in the United Nations, countries like Latin American countries suggest there should be precisely such a process for people who've had their rights violated by corporations operating in their countries, and they can't find legal redress against these corporations, it is precisely the US and UK that have vetoed any such legal access for those people. So what we call a right to redress against corporate abuse, which has been on the table since the 1970s in one form or another, has regularly been vetoed by the countries that push hardest for this legal avenue for corporations. So I think that tells you something, that we're not simply living in a nice little world where there are all these little sections of society and you've got to balance their needs, but actually there is a more fundamental conflict between different parts of society. And when capital or corporations grab additional powers in one part of society, that actually means that other people in society have their own rights infringed in many cases. And I'd argue that's what happens under ISDS. Truly, there is one rule for one and one rule for everybody else. And if you're already rich and powerful, it seems you deserve more legal privileges than if you're the poorest on the planet. So, and if this sounds like left-wing propaganda to you, I'd urge you to read a recent opinion of a conservative association of judges in Germany. Earlier this year, they issued an opinion, not on the traditional ISDS system, but on the specially zooped-up European Commission system of ICS. And this is the system that the European Commission has come up with to try and overcome the enormous opposition to ISDS in TTIP. And these judges, and as I said, there's several associations of judges in Germany, these are the most conservative, they rejected the proposal of the European Commission to establish an investment court, saying neither is there a legal basis nor the necessity for such a court. The creation of special courts for certain groups of litigants is the wrong way forward. The court is outside the institutional judicial framework of the EU and would deprive courts of member states of their powers in relation to the interpretation and application of European law, and the court of its powers to reply. So that's a really powerful statement by German judges that I think prove that what we're talking about here, and in many ways, by the way, I actually find the European Commission's proposal worse than traditional ISDS for the same reasons that I think the judges do. Because what you're doing in creating an international investment court, yes, you might have a better a class of judges who are involved in decisions. Yes, you might have transparency. But you're essentially putting on a completely legitimate footing the idea that certain people or certain interests should have special legal privileges that aren't open to anybody else. And I think that's exactly the case that the judges are raising there. Let me give you a case study. This is a ruling against Canada. That's in an ISDS case last year, brought under NAFTA. Canada held an environmental review to block a 152-hectare basalt quarry in Nova Scotia. They did this because they'd undertaken an environmental review, and the environmental review suggested that this area was an area of outstanding environmental beauty and importance. It was a key breeding area for several endangered species, including rare whales. But a US corporation, Bilcon, which wanted to open the quarry and argued that it invested time and money in trying to bring that process forward, argued that it needed to be compensated because this was unfair. And in fact, one of the interesting things is that they didn't just say the final decision was unfair, but Bilcon actually argued in the ISDS that the Canadian government shouldn't have resorted to an environmental review at all, that that in and of itself was a violation of the rights that Bilcon should have enjoyed. And Bilcon they've won the case and they're now going on to seek $300 million in compensation. Now, I bring this case up. This is one of many cases that Canada's been through. Canada tried to ban a toxic chemical from petrol many years ago, and they were sued by a corporation, and indeed they ended up with not banning the chemical after all. They thought it was easier just to keep it in the petrol, so that's nice for the Canadian people. And there's many, many other cases of this. But the reason I want to bring up this Bilcon case is it raises 2 points that I think are very interesting and that is often denied when you argue with proponents of ISDS. The first one is this case didn't relate to a breach of contract or to discrimination in favour of a domestic company over a foreign company. It simply related to a regulation which essentially a foreign corporation didn't like. Right? So all these arguments that it's essentially about breach of contract, it isn't. And case after case after case shows that to be true. The second is that this case is a challenge to Canada's ability to make decisions based on environmental protection, because the environmental review itself was at the heart of the case. So we're often told, don't worry about it, it doesn't affect the ability of a country to make laws, it just means if you do make a law, you might have to pay out several million or even billion, in some cases, dollars to a foreign investor. It's not true. In fact, this was pointed out by one dissenting voice on the arbitration panel. So this is one of the judges that sat on the panel. The arbitrator warned, a chill will be imposed on environmental review panels, which will be concerned not to give too much weight to socio-economic considerations or other considerations of the human environment in case they result in a claim for damages under NAFTA. He continued, the ruling will be seen as a remarkable step backwards in environmental protection and a significant intrusion into domestic jurisdiction. So that's what we're looking at. We're looking at a system here which places a serious chill on the ability of a government to do what it's been elected to do, or to protect those who its first priority should be to protect, i.e. the people and the environment of the country that they rule over. As I say, Canada's had many, many different rulings. Just days before the Bilcon ruling, there was another one where Canada had an award made against it for a regulation which required ExxonMobil, the oil giant, to invest some of its profits from offshore drilling in the local economy. Canada put a specific exemption in NAFTA to allow it to do this, but it was still ruled that it didn't apply to this case, and therefore they couldn't force a corporation investing in oil drilling offshore to invest in the local economy. You've heard about Australia, and I've already talked about the fact that people argue that's a good case of how these things work, but as I said, they were left with a $50 million bill, and it was only thrown out on a technicality. But there's something more important than that, and that's that New Zealand held off introducing plain packaging on cigarette packets for several years. They wanted to do this in 2012. They held off until now because this case was ongoing in Australia. So if anybody says to you it doesn't chill the regulatory environment, it doesn't put governments off undertaking laws, it's simply a lie. Because there is case after case after case where it's shown that it does put countries off enacting laws in the public interest. And there's plenty of evidence that the new ICS that's proposed by the European Commission will be just as bad as the ISDS in terms of all the cases we're worried about. So there's great work that's been done by Friends of the Earth and Corporate Europe Observatory in Brussels that show all of these cases will be just as possible under the new European Commission ICS. Indeed, it may be worse. One investor, and I love this quote, one investment arbitrator says of the EU's reforms, this is great. We used to have to argue about all of these foreign investor rights, and now there's just a great list they've come up with. I just love it when they try and explain things. So that's good news. There's no evidence that these things help investment. Of course, investors like them. I mean, there's no doubt about that. Obviously, you're going to like it if you're an investor. But that doesn't mean you wouldn't invest without them. And there's all sorts of other ways of going about your investment. And there's an insurance market if you want to buy insurance against the company, against the country defaulting on a project that's agreed to do with you. So I think for all of those reasons, it's little wonder that ISDS has become, in the words of EU Trade Commissioner Cecilia Malmström, the most toxic acronym in Europe. when a consultation was launched on what the European public thought of ISDS 2 years ago, 150,000 people responded. They'd never had such a response to the consultation. The website broke down, actually. And the vast majority of those people said no, and so they were accused of not being real respondents and of the consultation having been hijacked by NGOs. But it goes to show just how people get this very technical and dry-sounding thing as being a real infringement, a real problem, and a real obstacle to the realisation of democracy in our society today. And I want to end, because I'm sure my time is drawing to a close, and I want to end with a quote by a prominent QC, Toby Landau from Essex Chambers, and he says, "As a practitioner, I can tell you that there are states who are now seeking advice from council in advance of promulgating particular policies, in order to know whether or not there is a risk of an investor-state claim." So this is having a real impact on the passage of public policy right around the world. And therefore, I believe we absolutely have to, not just defeat TTIP and stop ISDS and TTIP, we have to begin a rollback of this in the hundreds and hundreds of other treaties that ISDS has contended. And that started. And the great news is that from South Africa to Indonesia to Bolivia to Ecuador, there are governments who are taking action to say, either we scrap these, or when these trade deals come up for ratification, for revision, because they normally have a review period built into them, we say we're not going forward with this, we're not re-signing it unless these ISDS provisions are taken out of it. And one of the things we can do, other than campaign to stop TTIP, which I think is the most important thing we can do, but the other thing we can do is show solidarity with those governments that are undertaking those measures, because very often those bilateral investment treaties are being signed with the UK or other European Union countries or the United States of America. Thank you.